Quick pause, this is already a mess. Sovereign citizens and their homemade paperwork never disappoint. Question for you all, why do they always choose the absolute worst situations to try this? Driving kids around while smoking? Let me know in the comments, because I truly want to understand the mindset.
All right, so we are convening, as mentioned, for a hearing on motion in case 2025 M42. The defendant is Ms. Jasenia Amber Raby. Ms. Raby appears today via WebEx. Ms. Raby, ma'am, it's Judge Murphy here. Can you hear me okay?
Yes, Your Honor.
Terrific. All right, and thank you very much for your appearance today. I hope you didn't get as much rain as we got overnight, so you probably were going to be in worse shape trying to navigate the roads today. But
fully, completely washed out, so.
Oh, well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, I just want to, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
Yes.
I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bema is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then also either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say is in writing.
Heads up, this is where sovereign citizens usually dig their own grave. Anytime a judge offers them a chance to explain their motion, they either read a script off TikTok or refuse to speak entirely. Watch how she picks option number 3, the silent, spiritual stare down.
Okay. All right, ma'am. Thank you very much. Mr. Bama, sir, do the people have any argument to make with respect to this motion?
Yes, Your Honor, we have argument, and then we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
I intend to call her briefly.
All right. Very good. Do you want me to swear her in now?
Yes, please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on right
No
now.
problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to myself?
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and I'll and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bama is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bama, sir.
Thanks. Is it okay if I stay seated?
Yeah,
Okay.
stay seated. There's no
Okay.
formality required.
All right, state your name, please.
Caitlin Bills.
And were you employed as of 4/29/25?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over the radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, 1 mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned. What was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane. While also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did, in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wranglers stopped at a stop sign on Grand Avenue in North Pine, and it had sat there for an extended period of time. Then quickly turned into the marijuana shop, Alpine Wellness in Norwood. Within less than a minute, it had pulled in there. He had given good descriptors of exactly what he had seen and observed and smelled. I initiated the traffic stop and contacted the driver to see the radio.
And what was your tone when you first initiated the stop?
Conversational. Well, when I first started it, I had yelled stop at her because she almost backed up into my car. But after that, it was conversational.
This is wild. The officer literally had to yell, "Stop," because she almost backed into a patrol car. Folks, tip of the day, if your traffic stop starts with the cop screaming for his life, it's not going to end with a dismissal. Not ever.
And was there anybody else in the car with the defendant at the time of the stop?
Yes. Her mother-in-law was the passenger, and then she had 3 young children in the back seat.
And eventually, you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood, and when she consented, she said that there would be THC in her blood.
Okay, and what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana. It had been outside of her car, and this was after she initially had lied to me about that she hadn't smoked at all, and she changed her story. But she had pulled over and she had smoked outside the car, and it had only been 1 joint, even though the car smelled like burnt marijuana on the inside, and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So, Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
I don't have any questions to cross-examine at this time.
Legal note. Declining cross-examination is a massive green flag for the prosecution. If she had a real legal argument, this was her moment to challenge the testimony. But sovereign citizens rarely cross-examine because they believe the court has no authority. Spoiler, it does.
I don't know if I think just for protocol,
Ms.
I'm
Raby.
gonna open up to Ms. Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasir, do the people wish to make?
Yeah, thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it. And the police must have specific and articulable facts or rational inferences from those facts, which would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills, and it started with a citizen informant, a ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time and not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop. And the site that I'll have there is kind of the cumulative reasonable suspicion is People v. Garcia, 789 P2D 190192, Colorado, 1990.
Okay, pay attention. This prosecutor is breaking down reasonable suspicion, which is the only thing the judge needs to justify the stop. This is the part sovereign citizens never understand. The officer doesn't need proof of a crime, just specific, articulable facts. And smelling weed, weaving, and slow driving checks all the boxes.
All right, Ms. Raby. I just want to make sure that I, as fully as I can, address some of the points that you articulate in your written motion. And then I'll also I'll layer in the discussion that the people have highlighted here about the reasonable suspicion or lack thereof, et cetera. But I think I did, as part of the record during your last appearance, inform you that in any criminal case, including this one, that the court has authority over that case as a result of Article 6 of the Colorado Constitution, Sections 1 and 16, as well as a basis being Colorado Revised Statutes, Section 13-6-106. Further, that Article 6 of the Constitution, the Colorado Constitution, more specifically Section 17, does grant the court subject matter jurisdiction, meaning that this type of act, this type of case is appropriate to be heard in the county court. In addition, that point is emphasized further by Colorado Revised Statutes 18-1-201 and Colorado Revised Statutes 13-6-106. I also noted for the record during your prior appearance, and will do so again today, that personal jurisdiction was in effect achieved or perfected as a result, first, of the issuance of the underlying summons complaint which was served to you by, I guess, Deputy Bills, yes, back on April 29th, 2025, during that traffic stop that was just discussed as part of her testimony. And then your personal appearance here on August 5th, 2025, also reaffirmed that personal jurisdiction, meaning I have authority over you as a person. I have authority over this case given the subject matter of the case. And with that, I also want to draw your attention to my oath of office then that was administered on the 8th of June 2020 by District Court Judge D. Corey Jackson, as well as the State of Colorado Department of State having issued a certificate certifying, more specifically the Secretary of State certified that on November 8th, 2022, that I, Sean Murphy, was duly retained as a county judge in the 2022 general election, that being the county judge for San Miguel County, Colorado. So let me turn then, with that background highlighted, to some of the assertions you make. Your document that's titled Lawful Challenge to Jurisdiction, Standing, and Authority, in which you say this is a lawful and peaceful demand for proof of proper jurisdictional standing. That I have just provided to you in terms of the county court's jurisdiction over this matter, more specifically subject matter, as well as you as a person, as well as my oath and retention certification. So therefore, that is proof of jurisdictional standard. You further provide, or you further request that we produce reasonable articulable suspicion, so also known as reasonable suspicion. So the people have addressed that in their argument, and the court, well, this is where we get into the ready report here. And as Mr. Bema has highlighted, that in this matter, in this particular case, there was this report from an off-duty San Miguel County deputy who did observe certain traffic violations, including the weaving, I suppose, as well as he had both seen and smelled the presence of marijuana emitted from the vehicle and seen you smoking what appeared to be a cigarette of some type. And so that information received from Corporal Nick Adams is something that what we call the totality of the circumstances has to be considered, as well as the circumstances surrounding what Deputy Bills observed directly that she just testified to. And so on that basis, I'm going to, at this point, for purposes of this motion, make a finding that reasonable suspicion did exist. The sort of test here is that, generally speaking, Colorado law provides that a ready report, that being that report every drunk driver immediately, it can suffice even on its own to establish reasonable suspicion for a traffic stop, but that the sufficiency of that depends on the totality of the circumstances, including the reliability of the information provided, which I'll make a finding that it on its face looks reliable, that a report was received from a reliable source, that being Corporal Nick Adams. So reliability of the information test seems to be, or is met, and therefore the court also is required to consider any corroboration by law enforcement. And so Deputy Bills's statement of her observations immediately prior to the traffic stop, while not direct corroboration of what Deputy Nick Adams or Corporal Nick Adams observed and reported, does support does support and is a factor to be considered. And therefore, the court having considered that, the court does find that reasonable suspicion did exist for this traffic stop. So with that, let me turn next to I guess this is on page 1 of that previously mentioned document. You've asked as item 2, the name and identity of a verified claimant. Well, the verified claimant is the state of Colorado through law enforcement agency, San Miguel County Sheriff's Office. So there is a verified claimant that is advancing this case in this court. Item 3, you asked for a sworn affidavit of injury. Well, there's no actual injury in fact, and so that's outside the scope of this analysis. And so therefore, an affidavit of injury is not something that's appropriate or required in this circumstance. Item 4, you asked for proof of lawful delegation of authority, and that's why I would refer you back to my oath and my retention that I mentioned earlier. And then item 5, you do ask for proof of lawful jurisdiction. And again, I've cited the Colorado Constitution and Colorado Revised Statutes sections that provide the lawful jurisdiction information that you were seeking there. So let me turn next to your second submission. That's the 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction, in which your first item on page 1 says presumption of statutory participation rebutted, and you claim that you need a written bilateral agreement bearing your signature in order to require your participation. And as Mr. Bema noted, that in his answer or his response that he filed on August 29th, 2025, it's noted under the jurisdiction explanation that pursuant to Colorado Revised Statutes 42-2-101, subsection 1, except as otherwise provided, no person shall drive any motor vehicle upon a highway in this state unless that person has been issued a valid driver's license. And well, the traffic code, let's go to point 2. Colorado Revised Statutes 42-4-103, stating that the traffic code, which you've been alleged to have violated, applies to all streets, roads, and highways throughout the state. So that is a supporting factor, very much so, in terms of the lawful jurisdiction here and the presumption that you'll be required to participate in this kind of a proceeding. Item 2 on that second document states there's a lack of verified claim and jurisdiction. For the previously mentioned reasons, there is not a lack of a verified claimant and there's not a lack of jurisdiction. You, in item 3, state that there's a rejection of public charge or democratic involvement. Public charge being a public benefit, I guess you are making, in fact, use of public roadways. And so I don't think that you can simply reject through your written submission the fact that you're not, because you actually did. You were observed on Highway 145 at 2 locations by an off-duty officer as well as a non-duty officer. So you were making use of the roadways, and therefore that's not a valid complaint or a valid argument against the search that was conducted. Item 4 on page 2 of your second document is titled Jurisdiction and Consent Challenge, and you cite Terry v. Ohio as well as Louisiana Defenders versus Defenders of Wildlife, and claim that you do not consent to jurisdiction. But for the reasons previously mentioned on the record here, you have consented by driving a motor vehicle on a Colorado highway. Item 5 in your second document indicates that notes that there's a contract and due process requirement, and you make reference to the Uniform Commercial Code, sections 1-103 and 1-308. So the Uniform Commercial Code has no bearing on a criminal law proceeding in the state of Colorado. So notwithstanding any registration you may have performed by filing any kind of a Uniform Commercial Code document with the Secretary of State, that is not relevant here. And so it's not an argument in favor, in fact, of your motion. Then you, as item 6, note an affirmation of self-determination and international law, and you state that you lawfully reject all presumptions of your status as a taxpayer, donor, ward of the state, and you do not accept or participate in any public charge or governmental benefit which would diminish your right to self-identification. I think it meant self-determination. So for the reasons previously stated, you have availed yourself of a governmental benefit, that being a public roadway. And so this argument is not persuasive to the court. So with that said, I am obligated for those for the reasons previously stated, the findings previously stated, to deny your motion in this matter. And therefore, what we next need to do is just set a return date for the next hearing in this case.
Here comes the sovereign citizen kryptonite. The judge is about to dismantle her motions using actual laws, statutes, and constitutional provisions. If you've ever wondered what happens when fantasy paperwork meets real jurisdiction, this is the moment.
We've made an offer, and I've discussed it with her at length before, and the conversation was the offer is going to expire if you go through with this hearing.
Mm-hmm.
I'm willing to. I mean, I don't usually have that hard of a line on that, so I'm willing to talk with her still, but otherwise we're ready to go. I mean,
okay, what if we came back in 2 weeks, October 28th at either 9:45 a.m. or 2 p.m. And then at that point, if that date and time, one of those times on that date would work for you, Ms. Raby, we would just be holding another what they call pretrial conference, and then there would be possible discussion of whether or not you were interested in taking that offer. And if you don't have to take the offer, it is your right, of course, to enter a plea of not guilty and to request a trial either to a judge or to a jury. And you can weigh those options between now and then as well as weigh the offer that you've received, and just let us know kind of where you stand at that point. Would that date and one of those times work for you, ma'am? October 28th, either at 9:45.
Sorry, I think
she froze.
She was
Yeah.
still muted.
Sorry about
there.
that.
Yeah.
Oh, I'm sorry, Ms. Raby. If you wanted to say something, can you unmute yourself?
Sorry, I didn't realize I still had myself muted.
No problem.
Yeah, October 28th should be totally fine. Can we do the 2:45?
2
Since I
o'clock.
have to get my kid to school and
Right, and let's turn to, I think it's either Jacinia or Yesenia Rabi. Miss Rabi, can you hear me okay?
yes, sir.
Did I say your last name correctly?
Can Raby. And it's
Raby?
Jacina.
All right. This is case number 25M42. Ms. Raby appears on WebEx. Mr. Bema for the people. And let's do this the same way. Mr. Bema, any update?
Yes, we had a hearing the last time on Ms. Raby's motion to suppress. There was an order on the record that denied that motion. I made an offer prior to that hearing to Ms. Raby. The offer prior to the hearing was stated will be revoked if we go through the hearing. However, at the hearing, I noted that if she still wants to talk, I'm open to those discussions. We have not had a discussion since then, so I'm not sure if she still wants to have discussions or if she is at this point going to set for trial. And Ms. Raby, if we do set for trial, this isn't anything to be rude or anything along those lines, but if we set it, then I can't engage in any more offers because there's certain work that needs to be done as a result of trial getting set. So I guess I'll kind of punt it back to you to see if you want to discuss any further or if you are at this point satisfied and want to set it for trial, knowing that there will be no more offers if we set it.
If you would like to discuss everything that I've filed and stuff like that, I would be willing to.
22 CR 7002, People versus Montez. Entries?
Daniel Cohen on behalf of the people.
And Robert Halpern on behalf of Mr. Montez, who is present in custody in the courtroom today.
All right, we're set for sentencing today.
That's correct.
Ready to proceed?
Yes.
Yes, Your Honor.
Prosecution?
Thank you, Your Honor. I will just initially note, well, as the court is aware, this is a case that it's a fairly small range of sentencing between 20 and 25 years. I am going to be asking for the 25 years. I
thought it
believe,
was, did I typo? I thought it was 24.
sorry, 2024, pardon me. That was the older, the previous one was 2024. I'm asking for that 24 years. I know, I think we're all aware of Mr. Montez's situation, but at the end of the day, this was a very violent assault against peace officers when they were trying to enforce the law and protect the peace and sanctity of the Denver Union Station bus station. As someone who has regularly used that bus station, I know how harrowing it can be at times. And I know the amount of work that RTD has put into that to try and make the public transportation system safer in this city. It's necessary for so many people, and for some of us, we want this RTD to be safe and enjoyable for everyone. And Mr. Montez, through his actions, severely disrupted that. And I believe that based on the nature of his offense, he has earned those 24 years. I will say that in preparing for this trial, in speaking to some of the officer witnesses, one witness, what stood out in my mind is when I asked him, what did you think when you saw what happened? He told me, my first thought was I just lost a colleague, because the stabbing was just that violent and aggressive. And thankfully, the officer who was stabbed repeatedly in this case, his vest did exactly what we hoped it would do. It prevented him from receiving any further serious injuries. It prevented him from being killed. But there were lasting effects in this case. The officer whose hand got cut suffered a fairly severe infection as a result of that, and is, I believe, still on desk duty as a result of that. His hand has never really gotten back to full functioning. This has affected a lot of people in a lot of different ways. There's a very large restitution amount, and I don't know if I haven't had a chance to talk to Mr. Halpern about this, so I will state that it's in excess of $20,000. So if I could have an opportunity to file a written motion, because it's divided between multiple different officers and expenses, so if I could have permission to file a written restitution request after conferring with Mr. Halpern about it, and I can get that done in the next week to week and a half.
To be heard before sentencing.
Halpern?
Thanks, Judge. It's been a difficult case. It's obviously quite old, and I've gotten to know Mr. Montez throughout the pendency of the case fairly well, and I know he would disagree with some of my characterizations and my raising competency, but I've seen kind of the highs and lows, if you will, and when he is what I think functioning on a competent level, he's very smart, asks really intelligent questions about the case, about his options, about what happened that day, and he's taken responsibility for it. And it was, you watch the video, and that part of it is hard to watch when he has the scissors. But there is a long standoff, and that's in front of an elevator.
I watched the video.
Okay. And what Mr. Montez is talking about, and you hear it on the video, is at some point they do say that he can go. Once he puts the scissors away, they wanted him to get rid of the scissors, and then the doors open, and he did think he was free to go, and he got rushed. I think it's pretty clear that they weren't going to let him go given the circumstances, but he believed that and stepped back onto the elevator, and then they rushed him, and he reacted. And again, it's scary watching that reaction, and I'm glad they were wearing the vests. And I'm also glad that Mr. Montez, before the trial, opted for this option. While it's still a hefty sentence he's looking at, I would be concerned about post-trial and what he'd be looking at potentially the rest of his life. Again, I'm not sure that Mr. Montez to this day agrees with the idea of mental illness and mental health. But again, I think when I've seen him on his medications and doing well, he is smart and thoughtful. And I would encourage him to wrap his head around that and understand that diagnosis. Obviously, that's the decision he's going to make. But when I've seen him at his best, he has a lot to offer. And I really wish him luck moving forward through the prison and then when he's released and how he handles that in the future. But I know he wants to speak, and I do wish him.
All right, sir, you have the right to tell me anything you'd like me to know about this case and what your sentence could be. I really have no interest in anything else. The only issue for this court is what should the sentence be?
All right, this is very important about the case and about the sentencing. Very important that my diplomatic community, highest degree, was automatically uploaded and in effect February 2023. It will be against my rights as a king and diplomatic community to prosecute me. Protocol. I am a king.
We've passed all that, sir. You agreed to plead guilty. The only question right now is, will I give you 20 years or 24 years? That's what you agreed to. So what is it you want? 20, 21, 24?
With diplomatic community highest degree, is what I'm trying to understand is that I'm not supposed to be prosecuted. So how is it
All right,
that
we're not having this discussion anymore, sir. You need to talk to me about the sentence.
At least
Your record has been made. You have no diplomatic immunity. I'm sentencing you to 24 years in the Department of Corrections. There's a 3-year period of mandatory parole, and I will give you, what's his pre-sentence confinement credit?
1,043 days.
1,043 days of
Can we do
pre-sentence
20?
confinement credit, and we will determine restitution within 63 days.